We have major breaking news that the anti-gun community is going to think is great news. Specifically, the Ninth Circuit Court of Appeals out there in California has granted en banc review and vacated the decision in the Teeter case, which, as you may recall, a three-judge panel decided that Hawaii's butterfly knife ban was unconstitutional under the in common use test of Heller and Bruin. That was the panel decision, but today the Ninth Circuit Court of Appeals has just vacated that decision, which was in favor of the Second Amendment, and decided to hear the case en banc. We'll break that down and what it means in just 1 second. Now, the anti-gun community is going to view this as a win, but I'm not sure it is. This may backfire big time on the anti-gun movement, and they may not be smart enough to know it, but they will after this video. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarm, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, this is major breaking news, not a super surprise, but here's what happened. The United States Court of Appeals for the Ninth Circuit out there in Hawaii, California, and several other states has just voted to hear en banc, which means the entire Ninth Circuit, we'll explain what that means in a second, to hear a case called Teeter versus Lopez, which is the case out of the state of Hawaii that had challenged, and successfully challenged, I should note, the Hawaii ban on possessing butterfly knives. A three-judge panel decided that this ban on butterfly knives was unconstitutional under the Second Amendment, because the three-judge panel concluded that the state of Hawaii showed neither that these butterfly knives were not common, they were not in common use, and they also failed to show that these were somehow unusually dangerous. Either one would have been sufficient to win for the Second Amendment, and the bottom line is the panel concluded that Hawaii could not justify its ban on butterfly knives. Specifically, the Teeter panel did the proper analysis that said, step one, butterfly knives are obviously arms. Using the Heller definition in arms, i.e. the right of the people to keep and bear arms shall not be infringed. You look to the definition of arms as set forth by the Supreme Court in Heller, and it's very clear that anything that can be used offensively or defensively is an arm. Certainly a knife is an arm, just like a handgun. It doesn't say firearms in the Second Amendment. It says arms, which includes other kinds of weapons and not just firearms. We know that, for example, in the Supreme Court in the 2016 case of Caetano held that stun guns were arms. Stun guns are obviously not firearms. So the Teeter decision here originally said that butterfly knives, being knives, are obviously arms, and thus at the plain text level, the possession, the keeping, which means to possess, the carrying, which means to, the bearing, which means to carry, of arms is protected. Therefore, the possession and carrying of butterfly knives at the plain text level of the Second Amendment is protected. Then, of course, you shift the burden to the historical analysis. The Supreme Court has already done the historical analysis when you're dealing with an arms ban case in Heller, which dealt with a ban on handguns in the District of Columbia. And the test that they came up with was whatever you want to say about is or is not protected. At the bottom line, the Supreme Court in Heller said that if an arm is in common use today, in common use by Americans for lawful purposes today, it cannot be banned. There may be other excuses or other reasons why you cannot ban an arm, but at a minimum, if an arm is in common use by Americans for lawful purposes today, that's Americans, not just a particular state, then it cannot be banned. Here, and again, because the analysis of the in common use test occurs, and this is very important to keep in mind if you're a legal geek out there or you're a lawyer, the in common use test occurs at the historical level of the Second Amendment analysis. This is extremely important because the burden is on the government at the historical level of the analysis. Well, the Second Amendment plaintiff or the Second Amendment challenger in support of the Second Amendment has to show that the modern day gun control law implicates the text of the Second Amendment, which is not that hard. Once that occurs, and a ban on butterfly knives, which is a ban on a type of arm, implicates the text of the Second Amendment, the burden shifts to the government. The government bears the burden at that point to do the historical analysis. And in the case of an arms ban case based on Heller, guess what? The analysis consists of simply applying the in common use test by Americans for lawful purposes, which is the constitutional test that the Supreme Court came up with in Heller, having looked at historical analog laws. And therefore, the burden is on the government to show that a particular arm they want to ban is, among other things, not in common use by Americans for lawful purposes, because if they fail to show that, it means it's in common use. If it's in common use, it cannot be dangerous and unusual because it's not unusual. So this is a very easy test for the Second Amendment community to win on because, again, we just have to look out the window while the government tries to prove its case, which is virtually impossible when we're dealing with the kinds of arms they're trying to ban today, such as, in this case, butterfly knives. So what happened today is that the panel, of course, originally ruled in favor of the Second Amendment, saying that the Hawaii ban on butterfly knives was unconstitutional. They then sought en banc review to the 29 active judges on the Ninth Circuit. I should note that 13 of the 29 judges on the Ninth Circuit are Republican appointees, 16 are Democratic. The chief judge of the Ninth Circuit today is an Obama appointee. The chief judge is always on an en banc panel. I should note that even though 29 active judges are on the court of the Ninth Circuit and get to vote for whether or not en banc is granted in the case, the actual panel is only 11 judges assigned to hear the case. So therefore, it's possible that a majority of those 11 judges assigned to a case could be predominantly Republican appointed. But even if that were to occur, the overall en banc case, I believe, or en banc panel of the Ninth Circuit, the 29 judges could vote again to take en banc and override a 11-judge panel decision in favor of the Second Amendment. So there's a lot of steps here that can go wrong for the Second Amendment community in the Ninth Circuit. Nevertheless, the decision that struck down Hawaii's law was vacated, which means that as of today, the Hawaii ban on butterfly knives is the law of Hawaii again, because the Ninth Circuit vacated that decision that the panel found that the ban on butterfly knives violated the Second Amendment. So two things happened. Again, the law of Hawaii is back in effect, meaning the ban on butterfly knives is back in effect, and now we're waiting for an en banc review. I should note, by the way, that one of the cases that could implicate all of this is the Duncan case, which deals with the magazine ban, and the Duncan versus Bonta case was just granted an order. I just saw an order today that there's an oral argument in the Duncan case on March 19, 2024. That's March 19th. You will see the en banc argument in the Duncan versus Bonta case dealing with California's magazine ban, because they're going to be interpreting the in common use test by Americans for lawful purposes and probably misconstruing it and getting it all wrong. The Duncan decision by the Ninth Circuit could implicate the Teeter decision, which is, again, both are arms ban cases. So that may be something to keep our eye on. But specifically what happened today in the Teeter case is the following order was entered by the Ninth Circuit. Here it is. I'll put it up on the screen. Upon the vote of a majority of non-recused active judges, it is ordered that this case be reheard en banc pursuant to Federal Rule of Appellate Procedure 35A and Circuit Rule 35-3. The three-judge panel opinion is vacated. Judges Owens and Bennett did not participate in the deliberations or vote in this case. So that's the order granting en banc and vacating the lower court decision, or I should say the three-judge panel decision by the Ninth Circuit. This is unfortunate. Now, with all this said, now the anti-gun community is going to view this as a short-term win, or at least a win, because they're like, hey, the Hawaii ban on butterfly knives is back in effect, and that decision in favor of the Second Amendment in the Teeter case by the three-judge panel has been vacated, so now we get another bite at the apple. Here is where I think this may backfire big time on the anti-gun movement, and that is this. Right now, as you know, we've covered this on the channel, in the United States Supreme Court, there are 5 some odd cases, including the Bianchi case involving Maryland's assault weapon ban, propaganda term, before the U.S. Supreme Court, pending a cert decision as to whether or not the Supreme Court is going to grant cert in one or more of those cases. The other cases outside of Bianchi are all arise from the Illinois ban, but I don't think the Illinois cases are going to be granted cert because those are interlocutory. There's no final judgment in any of those cases yet. It's still relatively preliminary. In contrast, the Maryland assault weapon ban of Bianchi, there was a final judgment entered, and it's already been up to the Supreme Court. Cert was granted, and it was GVR'd, meaning cert was granted, then it was vacated and remanded back for further consideration. So Bianchi's already been to the Supreme Court a couple years ago, unlike the Illinois cases. Again, no final judgment in the Illinois cases. And that's why I think procedurally, the Bianchi case is a cleaner case for this U.S. Supreme Court to grant cert in that case. The reason why I think this game that was just played in Teeter in the Ninth Circuit, it has the potential to backfire on the anti-gun movement is, I'm betting dollars to donuts that when you see the ongoing litigation as to whether or not cert should be granted in the Bianchi case and the Illinois cases, okay, this game by the Ninth Circuit in the Teeter case is going to be mentioned. And they're going to say to the U.S. Supreme Court, this is further proof that you, the Supreme Court of the United States, needs to get involved because these lower inferior courts, as defined by Article 3 of the U.S. Constitution, all the lower courts are inferior courts. These inferior courts and these inferior judges need to be spanked in these arms ban cases because they're simply thumbing your nose. They're thumbing their noses at you, Supreme Court, and your precedent in the Heller case. And even Chief Justice John Roberts, who is not necessarily the most courageous person out there when it comes to being a jurist, I think he is going to take note of these games being played by the lower courts. And the fact that the Ninth Circuit just did this in the Teeter case, in another arms ban case, is going to put further fuel to the fire, further fuel in the fire to help us out before the U.S. Supreme Court. So this Teeter thing may be a short-term win for the anti-gun movement, but it may actually turn out to be a very favorable development for the Second Amendment community because it's going to be yet another example of a lower court, another court of appeal, simply ignoring the Supreme Court precedent and refusing to do its job and playing games with the en banc. So again, we'll see how this plays out. We'll know more about this in the next couple months, but I have a feeling this Teeter game by the Ninth Circuit is going to metaphorically blow up in their face for the anti-gun community, but only time will tell. All right, hope you learned something here today. We'll keep you informed. Don't forget to follow me on X at 4Boxes Diner. Subscribe and resubscribe. A lot of people keep getting knocked off, I'm told, so please resubscribe to this channel if you've already subscribed, and make sure you're subscribed. And we will see you again soon here at 4Boxes Diner.
Orders up. Table 2A.